Good afternoon, everybody. Welcome to our event. Today, we're going to be talking about military service credit and deposits. This is a topic that we get quite a few questions about, and I'm hoping that all of you had a good time, like an easy time getting on and logging on and can hear me. I'm not going to just shout out and ask everyone to respond because otherwise we're going to get a ton of questions in Q&A. Now, just some basics before I start. My name is Mike Evans. For those of you who don't know me, I have been at OPM for like over 30 years now. And a lot of my time has been spent in our benefits officers training and development group. So now it's benefits officers liaison and development. So a little bit about myself for those of you who don't know me or those of you who are new. I've actually spent my entire career at OPM. I began working with lost and stolen checks whenever we actually still used to issue hard copy checks. I've actually processed both CSRS and FERS claims. I've done some training through the USDA grad school in partnership with them when OPM had an agreement with them. I've worked in our internal training branch, and for the majority of my career, I've actually been in our benefits officers liaison and development. I'm the liaison for most of DoD, as well as some other agencies. If you're with DHS, I'm also your liaison. If you are with the House or Senate, I'm also your liaison, Gallaudet, a few others. So for those of you who know me, hi, it's nice. I'm glad you're on. I can't really see everybody. I see our numbers going up though, so people are still logging on. But it's probably a good idea for us to get started. I'm going to break in a few sections and ask for questions. So I would ask that you hold your questions until I open it up for questions, and then I'm going to read the questions and answer them. Now, obviously, with the number of attendees, I'm not going to be able to get to everyone's question, and there are probably going to be a lot of duplicate questions. So just so you're aware of that, don't expect every question to get answered, but if you do have a question, feel free to ask it about what we're talking about. I will also give you some advanced information in that we do talk a little bit about USERRA, but I'm not really going to focus in detail on that because we do have a separate class that we offer from time to time regarding USERRA stuff. And I do believe there is a group internally within OPM that's not our office, although we're helping with that is eventually putting together a USERRA guide. So I'm not sure where that is in process. I think it's still in the beginning processes. So you may see that out either next year or the year after, but it's still in development. But I just wanted to give you a heads up about that as well. So let's get started. I am going to go to our presentation right now. Okay, so again, we're going to be dealing with military service credit and the deposits for those as well. Now, the objectives here are we're going to have you have the ability to explain the effect of not paying a military deposit and to understand and explain how military deposits are computed, and of course, the effect of paying those deposits as well. So what we really want to get across here in this class is understanding the information so you can explain it to a potential retiree. Now, the first thing that we want to focus on are definitions. Definitions are key. For any of you who've done research in looking something up, or if you're trying to find an answer to a question and you have to go into either the law or the regs, a lot of times where you really find the answer to this is in the definitions, because sometimes it's contingent upon that. I mean, if we look at, for example, I get a lot of questions about, well, is this period of civilian service creditable? I mean, obviously, we're talking about military in this class, but it would apply equally to civilian in that if we go to the definition of what constitutes civilian federal service and we look at the definition and that service doesn't meet that definition, then it's not. Okay, so in the same way, the definitions are really key. So our military service definition is military service is active duty in the uniformed services that is terminated under honorable conditions. Okay, so all those pieces are key in the definition of what constitutes creditable military service. Now, the big question that we always get are these discharges. Under honorable conditions is an honorable discharge. Also considered honorable discharges are separation because of hardship, transfer to the retired list because of age or disability, transfer to fleet reserves, furlough or military furlough to reserve forces, general discharges with the parentheses under honorable conditions. That has to be on the DD 214 as well. It has to be general discharge with the parentheses under honorable conditions. Just a general discharge by itself is not considered honorable. You do need that parenthetical beside it on the DD 214. Also, death in action is another one that's considered honorable. Now, dishonorable discharges, you do see these on occasion. I've seen a few of them, which is surprising because usually if they're dishonorable, a lot of times people don't even claim the military service or don't submit the DD 214 to their agency. And so we never really even see it in the OPF a lot of times, but I have seen them from time to time. So some of those that you may run across are under less than honorable conditions or other than honorable. Undesirable is also considered a dishonorable discharge. Bad conduct, unfitness, or desertion. Those are all considered dishonorable discharges. Under those conditions, that military service is not creditable at all. It's like it doesn't exist. Now, here's something that I get a lot of questions about. In fact, I'm sure some of you guys have probably run into it before too. Uncharacterized discharges. Now, if we go back to our definition, which again, leading me back to what I was talking about earlier, when we look at the definition of military service, creditable military service, it's military service that is active duty, that is in the uniformed services, that is terminated under honorable conditions. This is in the law and in the regs. It's in the definition of what we consider creditable military service. So uncharacterized discharges are not characterized as honorable, so we can't credit those. That's why we can't credit those, okay? You may have a DD 214 and the person has a subsequent one where the service is honorable still if it's uncharacterized because of the way the definition is worded in the law and the regs. We need a characterization in order to be able to credit that military service. So uncharacterized discharges are, we do see them on occasion. We're seeing them more and more now, usually for brief periods of service. In order for that services, any of those services to be creditable, the employee has to go back to the branch of service where that was performed and request a characterization of the service. If the branch of service does not assign a characterization to the service or they don't characterize the service as honorable, then we can't use it. Now, I know you get pushback from employees on this and they're saying, well, you know, I have this period here, but then I have this other period that's honorable. I wouldn't have been able to do this if this one wasn't. We still need that characterization. It's in the law and the regs. It's in the definition of what we consider military service. So again, I understand that you guys sometimes get pushback from employees on this, but uncharacterized discharges, they have to go back and get that service characterized. If it doesn't get characterized, we can't credit it. It's as simple as that. Now, what is the military deposit? Well, military deposit is money that's paid into the retirement fund for a period of active military service performed after 12/31/1956. There's no deposit for military service that was performed before 1957. I doubt that you guys are going to see a lot of these anymore, the pre-57 military service. When I first started over 30 years ago and I was actually in claims, I did see occasionally periods of military service that were prior to 1957. In fact, I actually saw periods of service, civilian service, that went back to the 30s and the 40s for people that were really up there in age and had a lot of federal service. But now you really don't see that much. A little bit of history as to why we require a military deposit for this service after 1957. It's all contingent upon Social Security. Prior to 1957, Social Security deductions were not coming out of military pay. So if a person had military service, OPM got the ability to use that in a federal benefit if that person later became a federal employee and had covered service and retired from the federal government, because there was no Social Security deduction coming out of that military pay. We could use that service. No one else was using it. If they didn't have military retired pay, we could use it to add to their civilian service and give them credit for it. Starting in 1957, however, military service started having Social Security deductions coming out. So what that meant was when a person separated from the military, if they qualified for a Social Security benefit, Social Security got the first opportunity to use that military service in the computation of their benefit. Now, as you know, as some of you have experienced, I'm sure with other instances of service too, is you can't get double credit for service. You can't get credit in two places for the same period of service. So if Social Security got the first opportunity to use that service, then of course they would use it. We couldn't use it. So what we did was, or the law changed and allowed people to pay a deposit for that military service. So essentially they're putting money into the retirement fund, paying deductions into the retirement fund so that we could use that service as well. So this is one of the rare instances where, okay, Social Security deductions are coming out after 1957, but if a person puts the money, pays a deposit into the retirement fund, we can also use that service and they can get credit for it. So that's where, now this Social Security also actually drives some of the instances where we get into the CSRS and credit for service. So we'll get into that in a little bit. But I just want you to understand the basics here, that the reason that people have to pay a deposit for military service after 1957 is because starting on January 1st, 1957, Social Security deductions came out. So Social Security gets the first opportunity to use that service. If they pay a deposit for it, then we get to use it as well. Now, when we talk about periods of military service, what are we talking about? We're talking about total years, months, and days from the date of initial entry onto active duty to the date of final discharge or final release from active duty. A single period of service includes consecutive periods where there's no break in service. However, for those of you who know our break in service for civilian service, you know we consider discrete periods of service for civilian service to be a break of more than 3 days. For military service, you can have as little as a day break to break it into 2 periods of service. So that's a difference here that you need to be aware of. Military service, you can have as little as 1 day break, and that will give you credit for that will break that military service into 2 discrete periods. For civilian service, we consider a break to be more than 3 days. Now, before I go on, one of the things I want to kind of talk about here too, when we talk about date of entry into date of final discharge, one of the things that we run into, and this is more of a staffing issue, but I just kind of want to mention it now because we do get a lot of questions about this. Sometimes agencies will bring people on board whenever they are on terminal leave, but realistically, they are not discharged yet. You really shouldn't be bringing people on while they're still on terminal leave. You should wait until that leave expires and then onboard the person, because what happens is a lot of times when you're onboarding people while they're on terminal leave, they're still technically in the military. They haven't been discharged yet. So you create this situation where you've got an overlap of military and civilian service, and it can create some issues. In fact, I just had a couple of those in the last few weeks, which is why I'm mentioning it. So just be aware when you're onboarding people, you really want to onboard them if they're coming from the military after they've been discharged, not while they're still on terminal leave. You can interview them and everything else, but really hiring them, you shouldn't hire them until after they are fully separated from the military, because it does create some problems. Now, let's talk about the amount of military deposits, and then I'm going to, after we finish this section, I'm going to open it up for some questions, okay? So when we talk about the amount of military deposits, we're looking at the percentage of the military basic pay while they're in the military plus interest. For CSRS people, it's essentially the same amount of retirement contributions, which is 7%. For FERS people, it's 3%. So if you're a FERS employee, your military deposit is going to be 3%. Plus interest For CSRS people, it's 7% plus interest. So what you do is you take the basic military earnings and that percentage, and that's how much you pay in a deposit. Now, there was a period of time where it changed for a little bit when increased deductions happened for a few years. It was 1999, and this, for CSRS people, the deduction rate for civilian service also went up. Okay, so it was from 1199, all of 1999, basically, it went up to 7.25%. And in 2000, it went up to 7.4%. And then in January 1st of 2001, rates resumed at 7%. Now, total basic pay, what we mean by military basic pay is the total basic pay received by the military member when the service was performed. It does not include allowances, flight pay, combat pay, etc. Okay, so now I want to go back for a minute and open it up to a couple questions. Does anybody have any questions on anything that we have covered so far? Please feel free to type them in the Q&A. Okay, I'm not seeing any questions right now. I am going to give you just a couple more seconds and we'll be prepared to go on. Okay, well, if you think of a question on anything we've covered up to this point, feel free to type it in. We're going to move on to the next section, and then we'll break again for some more questions. Let's see. Okay, so now we are going to talk about the eligibility to make a military deposit. Who's eligible? If you're an employee who is currently covered by CSRS, CSRS offset, or FERS, you can make a military deposit. Separated employees who are entitled to an immediate annuity, or the spouse or former spouse of a deceased employee who's entitled to a survivor annuity. Now, the second bullet is a little bit confusing, but we're going to talk about that. If the employee died while they were absent to perform federal active service, which is not National Guard service under Title 32, because you know that service is only creditable if it's followed by reemployment, then the surviving spouse can make a deposit for the employee's final period of military service. So that's something you need to know if you're dealing with survivor benefits. Now, deposits have to be paid in full to the employing agency before the separation date on which title to the annuity is based. So that means that deposit, that military deposit, has to be completed before the employee separates. And it has to be paid to the agency, and then the payroll office will send it to us. Payments made via payroll deduction are considered to be made on or before the date of separation, even if the date of final salary payment is after the date of separation. So say, for example, you were having payroll deductions and you're getting and you separated on the Friday or a Thursday because that was the end of the month. And realistically, let's just make it a Wednesday. So you separate on a Wednesday, which is the end of the month. The end of your pay period is that Friday. Well, you know, the payroll deduction is going to come out of that final pay period. So we may get the payment later, but it actually was authorized before you separate, because you separated at the end of the month, which you needed to do for FERS. You know, that payment still counts. So it'll come out of the payroll deduction. It'll be part of your final paycheck, and that will be credited. Now, a FERS employee who can retire on an MRA plus 10 retirement but postpones the annuity still has to pay the deposit to the agency before they separate. This is an important one because I've gotten this question a couple times, and a couple times people have separated an employee on an MRA in 10, and then they thought they could come back to us and make that military deposit. They really can't. So just be aware of that. When somebody retires on an MRA plus 10 and they postpone it, because that military deposit has to be made to the agency, they really have to do it before they actually separate from you guys. Unless they get reemployed again before they actually apply for benefits, in which case they're just a rehire, not an actual MRA plus 10 person. Now, where are these deposits made? Well, they're made to the employing agency payroll provider prior to separation. Again, most people are doing this through payroll deductions rather than like paying the person directly, although there have been occasions where people have sent checks to their and paid things off in a lump sum to avoid accruing interest. Now, who should make a military deposit and what happens if you don't? Well, here's where it gets interesting. Remember I had talked earlier about Social Security. Well, here's where this really comes into play, and it's really because of CSRS. Because remember, CSRS people aren't subject to Social Security deductions from their regular civilian pay. So you could be a CSRS employee, work for 30 years, and not do any other work, and then retire and have never paid into Social Security because Social Security deductions don't come out of CSRS. CSRS, when you're covered under CSRS, you don't pay into Social Security. It's as simple as that. But under FERS, Social Security is a part of it. So if you're first covered by CSRS before October 1st, 1982, remember October 1st is a fiscal year, so it would be October 1st, 1982, post-56 military service will be credited at retirement, but it'll be eliminated from CSRS retirement benefits when the employee turns age 62 if they're eligible or upon proper application would be eligible for OASDI or Social Security benefits. That includes a CSRS component under FERS. So if you had a CSRS component and you were first covered by CSRS prior to October 1st, 1982, and you had military service in that CSRS component, initially we're going to credit the military service as if you retire before age 62, we're going to credit the military service in your retirement, but at age 62, we're going to check and see if you're eligible for Social Security benefits. If you are, then we're going to delete that military service from the computation of your annuity. Now, this brings up some really interesting scenarios, right? So let's say you retire after the age of 62 and you're in this situation. You've got some post-56 military service. You were hired under CSRS, let's say in January of 1980. So it's prior to 1982. Well, then you've got some military service back in the 70s. That's fine. You didn't pay a deposit for it. You retire after age 62. Well, because you're already at the age where you would potentially be eligible for Social Security benefits, we're going to check at that time when you retire and see if you're eligible for Social Security benefits. If you are, then we can't use the military service at all. If you're not, then we'll go ahead and add the military service into the computation of your benefit. Now, let's flip this a little bit. Let's say, same scenario, you were onboarded in January of 1980, so it's prior to October 1st, 1982. You had a period of military service in the 1970s, and you want to get credit for that. You retire, let's say at age 56. And then you are retired for about a year and you say, you know what, I'm a little bored. Let me go work at CVS and do something, you know, nothing really demanding. Let me just work and do something, and you're earning money and you continue this for a while, and it's enough to give you eligibility for Social Security benefits. Well, when you turn age 62, we're going to check. And even though you weren't, based on your federal service, you weren't eligible for Social Security because you had worked in private sector, that counts towards your Social Security eligibility. So if you become eligible, again, at age 62, we check. Social Security, remember, takes into account all earnings. So if you ever worked in private sector, that counts too. And if you're eligible, again, we can't use that military service. Now, Post-56 military service won't count for FERS retirement purposes unless the military deposit for the period of service is paid in full before you retire. This is the same thing if you were hired on or after 10-182 under CSRS. If you're hired on or after 10-182 under CSRS, or if you're a FERS employee, you have to pay a military deposit for any period of military service, regardless of Social Security eligibility, in order to get credit for it. Okay. I am going to jump back really quickly because that was a lot of information, and I see we do have some questions, so I'm going to look through these really quickly, and then we're going to answer these. Okay. The ID actually started first covered position. Okay, we have an interesting question here. When an employee has overlapping military and civilian service during terminal leave, what would be the IAD? Well, we're going to get to the IAD in a minute. For those of you who don't know what that is, that's the interest accrual date. The date actually started FERS covered position, or a day after the military service covered by the DD-214, even when the employee has already started FERS covered CIV civilian position. That is a problem, and this is one of the issues that happens when you onboard somebody while they're in a terminal leave status, because they technically haven't been discharged yet, but now you've got them in an overlapping civilian position. The problem with that is the interest accrual date, the law is really clear on this, is that it starts the day that you start a covered position. So you're actually starting to accrue interest even though you haven't been discharged, which creates kind of a mess, right? Because you're still in this position and you're getting charged. Essentially, the clock has started. You're not getting charged right away. You know, we'll talk about that in a minute, but the clock has started. So you can't even really pay that deposit until you're completely discharged, but yet the clock has already started running on that because you were employed before you were discharged. So if you can see the problem with that, that's just one of many problems, because then we get into deposits and other things. So again, I would really advise you to avoid confusion. Do not onboard somebody until the terminal leave is expired. I know agencies do this. It just really creates some issues. Let's see. We've had problems with DD-214s with an administrative or miscellaneous discharge, especially for boot camp. Can these be creditable since the departments refuse to correct these to honorable? No. We would need a characterization of that. This miscellaneous discharge I've never even seen, but to my knowledge, that is not considered honorable at all. So generally those are not creditable. Again, they'd have to go back and get those characterized. Generally something like this, they started something and they just couldn't complete it. Will these slides be available for download? We should have these all accessible. Will you accept a statement from VA that includes the characterization of service as honorable, even if the DD-214 has uncharacterized? I think you're talking about the transcript of service. And if the transcript of service shows the service as honorable, we can accept a transcript of service in lieu of a DD-214, but we do need a characterization. And if one is characterizing it and we have both documents, to me, that seems like I suspect if I was a specialist processing a case and I saw one where it was uncharacterized and one where it was honorable, I would be looking at that and trying to figure out, well, what happened here? Is there a discrepancy? Did somebody petition and then get a characterization assigned or what? I think that would eventually, if the honorable characterization held up, if that happened subsequent to the DD-214, then I think it would be acceptable. But if we've got something where there's a discrepancy, we're going to have to look at that. That's something that, it's like two different dates of birth or something. We're going to have to resolve it and find out which is actually correct. So it may initially hold up a little bit of processing, but we do need to resolve which is correct, or what the reason is why we have one that's uncharacterized and one that's honorable. Again, like I said, if the VA includes a characterization that shows honorable, it is probably likely that that service was characterized later on. We would have to look at it. Let's see. If 2 periods of military service are back to back, do not have a separation of at least 1 day, and one has uncharacterized and the other is honorable, are both periods creditable because they count as one discrete period? If so, does it matter which order the characters of service are listed in? Okay, interesting question. If you have 2 periods of military service and they're not even broken up by a day, they are essentially 1 period of military service. And so the later DD 214 that shows the character would be the one that would carry the characterization with it. So if we're looking at that as 1 discrete period of service, is not 2 periods of service, but as 1, if there is literally no break and the person has 1 continuous period of service, because that's how we would treat it, we wouldn't allow them to only pay for the second period or the first period. They'd have to pay for the whole thing. And the latest one shows honorable. That should work. I believe that is correct. Why isn't the military deposit reflected on the SF-50? Well, the 50 is a civilian document. A lot of times that payroll information is not captured on there. Maybe somebody would put it on remarks, but I've never seen it done on an SF-50 before. Okay, if somebody had military service before 1957, I just lost there we go. If somebody had military service before 1957, they would be no younger than 83 right now. At what point will that no longer be a talking subject? Well, I really don't know. We would essentially have to wait for, we have some very old soldiers, and conceivably they could be working for the federal government. I wouldn't want to put an expiration date on anybody. We have seen people, I've personally seen people with over 60 years of federal service, civilian service. So for me to put an end date on that, I don't know. We could conceivably have somebody who's working for the federal government past 90. If that's the case, realistically, if it was 90, we've got at least 7 more years to go. So I'm not sure that I can give you an actual date there. Okay, I have to come back to that. Okay, we've got a question here about an employee that was in the Navy active duty and then separated honorably, joined the Army National Guard, and then retired from there. Can the employee pay the military deposit for the time while in the Navy? If they're a civilian employee, if they are a civilian employee currently employed and they have active duty military service that is creditable, I'm assuming that would be the 93 to 2002, as long as they're not receiving military retired pay. There's a whole other issue with military retired pay as to whether or not it would be creditable. There are conditions where it's creditable if they don't waive it. There are a couple instances where that can happen, or if they waive it. We really have to look at that. But either way, normal rules would apply for the active duty time as long as they're currently on the agency's rolls and they are eligible to pay that, and they would be as long as they're subject to CSRS or FERS deductions. I don't see any reason why that wouldn't happen. Okay. Okay, we're getting a question here about the documentation requirements for the annual training for reservists. There's been some issues regarding the documentation with our shared service center that process the deposits. A lot of times people don't even pay a deposit for those 15 days because a lot of times they're on leave without pay, and that usually doesn't doesn't matter because they're not exceeding the 6 months. But I mean, it would be the orders, the signed orders showing that they were actually there and that they got paid. That's the case for a lot of times if we don't have a DD-214, if we need some backup documentation, or for individual periods of service, if you have the actual signed orders showing that they actually performed the duty, and the orders explain what the duty was, that it was Title 10, that it was creditable and everything, then, and it actually has the dollar amount that they were paid, we can usually work with that. Okay, so how do we, and so I'm getting all the questions about terminal leave. Essentially, just as and they're all revolving around the same things, and you guys are seeing the issue. You're asking the right questions, which is great, because you're asking, well, how do we deal with this? Because they're in the civilian and they're military simultaneously. What do we use for dates? That has always been the issue, is how do we deal with this? And the real issue is that the military service is from entry into active duty to discharge. So they're technically, that's still military service, even though you have an overlap with the civilian. So it does get to be a bit of a problem. I mean, their military service does overlap. So on the certified summary of service, you're going to see this, where you're going to have a from and to date that's going to overlap the civilian service, and that does create a problem. I do see that we have a question about the percentage. I was wondering if this question was going to come up. I was thinking it would. So the percentage stays at 3% even for the military deposit, even if the person is under FERS, FRE, and RE. That is correct. And if you remember, original FERS deductions are 0.8%. So when and we'll get into this a little bit later, but remember USERRA, when it was really a question about, with USERRA there, and we'll get into this a little bit later, but there's the alternative deposit where the deposit can't be any more than the retirement deductions if it's leave without pay US. In some cases, because the FERS RE and FERS FRE, this has really changed how you're going to do that comparison, because it used to be with FERS deductions being 0.8% and military deposits under FERS being 3%. In most cases, it was when we did the alternative calculation under USERRA for the military deposit, which would have been the most that the person would have paid had they just had their regular retirement deductions come out. Usually that came out to be more advantageous than the 3% military deposit in most cases. With FERS, when we added FERS RE and FERS FRE, because you're talking about 3.1 or 3 and 4%, you're looking at substantially more. And now those alternative calculations, in a lot of cases, the actual military deposit at 3% may be more advantageous. So it's just one of those things that when you do the comparison, that you're going to have to pay a little bit more attention to, because with FERS RE and FERS FRE, it gets a lot closer. And in some cases, the military deposit is actually going to be more advantageous than it will be to use the deductions. They get to stay on leave without pay US. Okay, that's a pay and leave question. I'm going to have to come back to that. Okay, when are orders acceptable documentation for military service for the purpose of deposits? I mean, orders are great if we have nothing else, but we do need more than orders. We need signed and stamped orders showing that duty was performed. Again, our gold standard here is the DD-214. We may need subsequent documentation depending on what it is. So just be aware of that. I mean, what we're really looking for is the characterization of service. We need to know that this was honorable duty, that it was active, everything. So it's DD-214 or equivalent. So when you think of all the information that's on the DD-214, remember that we need that. How do we process the deposit when it comes to cases that overlap? Again, we're talking about the terminal leave issue here. Again, you have to wait until they discharge. The estimated earnings are going to be from entry on duty to discharge. So there's going to be a period of time where they're going to be paying double. If they make the military deposit, they're going to be paying a military deposit covering entry on duty to discharge date. And within that, you're going to maybe have a period of overlapping civilian service. So in those cases, it's really not even advantageous to the employee because they're paying double the amount. So that's just something to be aware of. Let's see. Okay. We've got an interesting question here. A current employee had 4 years of Army service and retired from the military based on a disability. It was not combat incurred disability. In talking to the employee, he waived his military retired pay in order to collect compensation from the VA. Would he need to waive that VA compensation at retirement like he would with the military retired pay? Generally not, because VA comp is we generally don't pay attention to. It's not really, at least for FERS. For CSRS people, VA comp comes into play, particularly with disability computations, but for FERS, for the most part, VA compensation doesn't really come into play. Okay. Well, here's an interesting one that we do get on occasion. What if the DD 214 says other than honorable? Can't use it. I believe that is in one of the previous slides where it's other than honorable. That is not an honorable discharge. So that service is not creditable. They can't pay a deposit for it. It's just not creditable at all. You can't use that military service at all. Okay, I see a couple questions about interest accrual dates. So we're going to wait because we're going to get to that. Okay. Okay, so let's move on a little bit. We've gotten through some questions. Thank you, guys. These are great questions. We are going to continue on a little bit. I know we've gotten some questions about interest accrual dates, and we're going to be moving into that. So I really want to get to that part of the presentation as well so we can continue that. I think that'll answer a lot of your questions on interest accrual dates. Now, before we get to that, though, we're going to talk about the employee and agency responsibilities. It's really important that the employee knows what they're responsible for and you as the agency know what you're responsible for. So the first thing that an employee needs to do is they need to go to their agency HR office and ask about making a military deposit. Now, I know in some cases, agencies are reaching out to their employees as part of, in fact, I've seen this in some of your financial education and literacy plans that you've submitted to us, that agencies are being very proactive now about reaching out to employees when they return from active duty, if they've been on active duty, or if you're onboarding them. A lot of times agencies are asking people if they have prior military service and are dealing with this issue right away. So in some cases, you guys are already addressing this as the agency and being proactive yourself, but it is, at the end of the day, it is the employee's responsibility to reach out to HR and ask about making a military deposit, but I'm really glad that you guys are doing this as well. They obtain the SF 2803 or 3108 that's modified for the military deposit from their agency. Actually, we have those online now, and there is a whole separate section. They don't need to be modified anymore. We've got one part of that form that is for civilian deposits and another part that is for military deposits. In the old days, we used to have to modify it because we only had one. Then you're going to complete the appropriate section of that along with a copy of the DD 214 or the equivalent record to verify the service. You're going to submit an SF-180, the request pertaining to military records, to obtain a copy of the DD-214 from the Military Records Center if a copy isn't available, or you can go to the archives or VA and get that online. In both places, they actually are providing those now. Provide the documentation of military basic pay to the agency. You can get the estimated earnings, or you can use actual pay records from military service. They're going to submit the RI 2097 and the DD 214 to the appropriate branch of service if actual pay records are not available. And Chapter 23C of the CSRS and FERS Handbook contains some examples of all this stuff. These are old forms. It's actually easier to get these online and look at examples of them now. We are in the process, as you know, of updating the handbook, and some of our chapters have been updated. We're making progress on that. The military chapter, as you can imagine, is quite a substantial chapter, and we have some things changing. It's kind of like a moving target. So this chapter in particular is one of those that's kind of difficult to update. Similar to the coverage chapter, which has been updated, Chapter 10, our general coverage chapter, has been updated, but that was kind of a challenge as well because we kept having changes to coverage like CSRS, like FERS RE and FERS FRE, and of course all the FERCA information. So the military chapter is kind of similar. We've had some things going on, so just be aware that that has. Now, again, employee responsibilities, pay the deposit directly to the employing agency. Payments can be made in a lump sum. They can be paid in installments, but however they're paying them, payments must be completed prior to retirement. That's the employee's responsibility. Now, the employing office responsibility, you're going to have to explain the effect of not paying a deposit for post-56 military service to all employees who have military service. So just be aware, you know, for FERS people, it's really simple. If you don't pay for it, you don't get credit for it. If you're a CSRS employee who was hired on or after 10/182, again, it's really simple. If you don't pay a deposit for that military service, you don't get credit for it. It's the CSRS people first hired prior to 10/182 that this explanation, as we talked about earlier, gets a little bit more convoluted because now you have to talk about, well, you know, it depends on whether or not you're going to be eligible for Social Security at age 62, or if you retire later than 62 or earlier and you decide to work. So yeah, there's that whole discussion that we had earlier. So again, for most people now, it's most of your employees are going to be FERS people. So it's pretty straightforward for FERS. If you don't pay the military deposit, you generally don't get credit for it. You're going to counsel employees to document the basic pay earned as soon as possible upon employment, and you're going to caution employees that a deposit has to be made before they separate. This has to be done before separation. You're going to talk about the effect of paying a deposit for the military service when they ask about making it, and explain the application process to the employee. So, you know, you're going to tell them essentially, well, you're going to get credit for this service, and this is going to increase your annuity by X%. And if they're close to retirement, hopefully they're making this deposit earlier rather than like, you know, a month or two before they retire, because it's hard to get all that documentation together. And since they have to pay it before they separate, that can be a bit of a challenge. But, you know, you can explain in general, if they're doing it very early in their career, how this is going to affect them. It's going to give them, you know, additional time, which may allow them to retire earlier. It could flip them from an MRA plus 10 to a full retirement. There are a number of things that this, you know, it's going to increase their annuity and everything else. So if they're close enough to retirement, like within 5 years of retirement and they're doing this, you can give them an annuity estimate even, and that can give them an idea of what they're looking at. Again, you're going to either provide them with the 2803 or the 3108. You can direct them to OPM's website where those forms are located. You can help them fill them out if you want. Again, the CSRS and FERS Handbook has that if they needed to be modified. Again, I'm keeping this old information on this slide, talking about modification, because if somebody has paid a military deposit at a prior agency, you may see this in some cases. You may see a copy of this where there's a statement on, originally we used to have the 2803 or the 3108. these forms were old and they essentially were just for civilian service, but they were modified and there was a statement typed on there. It still shows in the handbook, the statement that basically says that this is a military deposit, blah, blah, blah. You don't need to do that now. Now we've actually created the form so that there is one page you can fill out for civilian. There's another page that you can fill out for military. So we've made that a lot easier for you. You're going to accept the form and the documentation of basic pay and review them for completeness. You can assist the employee in requesting verification of military service and or estimated earnings. I know a lot of agencies will do that for the employee. You're going to compute the military deposit using OPM 1514, the military deposit worksheet, or an equivalent. I know some HR offices do this. Some of you guys, your payroll office does this, or your shared service center does this. However you do it, you know, the military deposit needs to be computed. You notify the employee of the amount due and the options for making a payment and how payment can be made. Normally, payments must be at least $50 if they're doing it in installments. Again, a lot of this is going to happen at the shared service center as opposed to the HR office. You're going to be establishing a deposit account, enter the payments on the OPM Form 1514 or the equivalent, prepare a separate 2806 or 3100 individual retirement record to document the military deposit. Now, see, this is the other thing as well. A lot of times, agencies, I've gotten questions from some agencies that for some reason think that OPM needs a paid in full letter for the military deposit. We don't. We don't really, I don't want to say we don't care about that letter, but realistically, in most cases, we don't. We don't even need that letter in most cases. It's a great secondary document if there's a question about whether the deposit was paid or not. But if the military deposit was paid correctly, it is paid to the shared service center or payroll provider. That, as if you look at the last bullet, is documented on an SF 2806 or 3100, which is the payroll card. That is sent to us on a register, and just the same way any other service is sent to us. And we have a payroll card, and that money is sent to the retirement fund, and that payroll card shows paid in full. So that's what we're looking for. Even if you had a paid in full letter, we would still need the IRR, the 2806 or 3100, showing that that money came to OPM, because a paid in full letter by itself shows paid in full, but it doesn't show us that the payroll provider sent us the payroll card. And if we don't have the payroll card, we don't have the money in the retirement fund. We need that. Okay, so our gold standard is the SF 2806 or 3100, that IRR, that payroll card. The paid in full letter is something great for the employee to have. It's great subsequent documentation if say a question arises and an HR office says, well, did you pay your military deposit? The employee could produce this, or if they come back later and get rehired somewhere else, they have this piece of paper that they can say, yes, see, I paid it in full. And if they have that and they present it to OPM, if OPM is saying we don't have an IRR on file and the employee produces a paid in full letter from that shared service center, that as secondary documentation is great for us to reach back to that shared service center to say, hey, an employee provided us this paid in full letter, but we don't have the payroll card from you. We need that money. We need that documentation of service. You need to send that to us. So again, the letter is nice secondary documentation, but the last bullet here is key. That is our gold standard. That is what we need, that IRR, that payroll card. Now, the employing office is going to retain the original OPM Form 1514, the documentation of basic pay, the military deposit application, and the IRR for submission to OPM, along with other retirement records upon separation, transfer, or death in service. Now, at retirement or death in service, the employer or survivor is going to complete the OPM Form 1515 or 1519. That's the military service deposit election, indicating their decision whether or not to complete the deposit and submit it with the application package. There's also a question on the application. indicate on the certified summary of federal service whether the employer or survivor has applied to make a deposit and whether it was completed. You're going to counsel the employer or survivor on the effect of not paying a military deposit, providing annuity estimates with and without the military service if the deposit has not been completed. Now with survivors, remember, because for FERS people, in order to qualify for a survivor benefit, they need at least 10 years of service. A lot of times this military service can make a difference as to whether or not somebody gets a survivor benefit, or if it's a death in service, they just get the basic employee death benefit. So sometimes that military service, in the case of a survivor, is going to make the difference if they pay the deposit or not as to whether or not they get a survivor benefit or not. In some cases, even if they pay the military deposit, it's not going to give them a survivor benefit. Okay, so when you're counseling a survivor, this is where this really comes into play. So say you've got somebody who has 4 years of let's just even give them 5 years of civilian service, and they've got 3 years of military service. Well, if that survivor pays a deposit for that 3 years of military service, they're still not going to have the 10 years of service necessary to get a survivor benefit. So paying that military deposit is going to do them no good at all. If you have somebody who, say, has 9 years of service and they've got 3 years of military service and they pay the survivor then pays that deposit, that is going to give them a survivor benefit. And so that would be in their best interest to pay that military deposit. So again, you have to look at this on a case-by-case basis. Just be aware when you're working with death in service in particular that this is where the military deposit may or may not make a difference, and this is where the counseling on your part is going to be really important. You're going to inform the employee or the survivor that the deposit must be made in full to the employing agency before separation, or if it's a death in service, before we complete the adjudication of the annuity for the death in service case. Now, documentation of military earnings, the employee is going to either provide the documentation of basic pay to the agency, the estimated earnings, or actual pay records from the military service. Now, if you're going to use actual pay records, you have to have every one. You can't use partial ones. You can't use part pay records and part estimated earnings. It has to be the whole thing for each period of service. So to use actual pay records, you have to have complete pay records to identify the exact amount of pay earned for the entire period of service. So from entry on duty to discharge date, you have to have literally every pay record for that entire period if you're going to use actual pay records. If you're just using estimated earnings, you just use estimated earnings. If complete pay records are furnished, the agency has to use them. You can't pick and choose. I mean, if an employee provides complete pay records for every pay period during that entire period of active duty, from entry to discharge, you have to use them because that's going to give you the exact amount of earnings, and that will make the military deposit the most accurate. Otherwise, if you don't have that complete stuff, then you can use estimated earnings. Okay. I am going to, because we covered a lot, I'm going to go back and see if we have any questions. Let's see. Documentation requirements for annual training, we talked about that. Okay. What if an employee retires, then comes back with a DD-214 that says characterized but was not that way when they retired? I'm assuming that this is a situation where somebody was kind of late in making their military deposit, like they were doing it at the last minute, and the only way I can see that this situation would come up would be a situation where somebody had a period of service that was uncharacterized, They wanted to make a deposit for their military service, but it was uncharacterized. They petitioned to have a characterization assigned to that military service, and as a result, they got it after they retired. And so in a situation like that, you wouldn't have been able to accept the military deposit. And the military deposit has to be made by the employee to the employing agency before they separate. The only way that you get around that, and there's a BAL out on this, and I know we get a lot of questions about that anyway, and that is if there was administrative error, and that's something that only OPM determines whether that's an administrative error or not. If the agency made an administrative error that would have prevented the employee from making a military deposit. Well, in this case, if this is somebody who, we'd have to look at the whole situation, but the only way I can see this happening is it's something that happened because the person didn't decide to make the military deposit until they were close to retirement. That is not an administrative error. That's somebody just not doing what they needed to do at the time because they waited so long and they decided to retire without waiting to get the information back. There's no reason that an employee, in most cases, I mean, I suppose there could be a DSR or a disability or something like that, and that brings in a whole other set of questions. But realistically, if the person had, as soon as the person came back from active duty, they would have had an opportunity to make a military deposit. If they waited until close to retirement and stumbled across a DD-214 that was uncharacterized, and then they petitioned that branch of service for a characterization, they should not have retired until they got that characterization, at which point then they could have paid the deposit to the agency before they separated. If they had a period of uncharacterized service, you wouldn't have been able to accept the deposit, and then if they chose to retire anyway, that service is not creditable. I don't see that as being an administrative error. I don't see that any of our legal administrative specialists who would make a determination on that would find that as an administrative error either. That is something where somebody, in most cases, like I said, unless there was some extenuating circumstance, if they retired voluntarily, they retired voluntarily. They had a choice in that. And so, you know, they could have waited until they got the information back and then made the deposit, but we can't accept it after they've separated. Does the dishonorable discharge definitions carry through to the hiring authorities? Okay, that is more of a staffing question, and I honestly do not know. However, my guess would be that it really wouldn't be creditable because dishonorable discharges are not, but that is a question that would need to go to our staffing group. You might want to check with your staffing specialists at your agency first. I'm sure they have the answer to that. My initial thought is, though, that military service would not be creditable or anything like that. Okay, I know one form of acceptable documentation is a letter on military letterhead noting active duty, inclusive dates, and honorable discharge. But when I inform my employees about this, they have no clue where to get such a letter, especially if they are in the reserves. They would need to go back to their branch of service. So if they're Army reserves, they'd have to go back to Army. I know that they can get this. It's pretty straightforward. They go back to the branch of service. If they go back to their command, they should be able to get that. Okay. Okay. Yeah, and okay, and again, we're getting a lot of the same questions. Sorry, I'm scrolling through these. An uncharacterized discharge can become characterized if the customer reaches out to the branch. Correct. Okay. Lump sum payments would go through your shared service center or your payroll office, just like any other ones. Let's see, I'm seeing a lot of these. Sorry. Okay, we're getting into some interest questions here, so I'm going to get to that in just a minute. Okay, I've got one here. Again, we keep getting the question about the terminal leave. I mean, realistically, for the military deposit, they have to pay, if they want to pay the military deposit and get credit for that, they have to pay for the full military deposit from entry on duty to discharge date. If you onboard them before then and you're withholding retirement deductions, then, and they don't pay the military deposit, the entry on duty date for you in their civilian position to their retirement date is what you credit, but they get no credit for the military service. So, but that again, you're affecting SCDs because you've got an overlapping period and we can't give dual credit. So, you know, again, there are some complications. We need to look at those on a case-by-case basis. I can't give you guys, but generally, I mean, this is what we're looking at. If you've got military service and you don't make a deposit for it, then none of that military service counts. Yes, the civilian service would count, you know, from their entry on duty date, as long as it's covered, to their discharge date, as long as they're full-time, as long as they are, you know, in a civilian position. So, but for the military service, again, it's, they're going to have a period of time where it's overlapped and they're going to be paying a military deposit for the same period of time that they also have civilian deductions coming out, which creates, again, you know, as I said, some issues with SCD, but that realistically, that situation should not happen. And I know some of you are like, well, I don't do the hiring. Okay, I understand that, but for anyone who does or can reach out to their, I mean, this is something that we do need to get across to agencies at some point, is if you're onboarding somebody, you should really wait until their terminal leave expires before onboarding them. Let's see. Okay, the military often does not provide a DD-214 for periods of service under 90 days. What documentation can be used in lieu of the DD-214? An equivalent, which would be the transcript of service, entry on duty discharge that it is honorable act of service, that the service was performed honorably. It would be the transcript of service. Let's see, is paid in full receipt required with a retirement package? Again, it's nice secondary documentation, but not necessarily. What we really need is that payroll card, that IRR, that 2806 or 3100 that your payroll provider will send to OPM, that will, and they will have transferred the money into the retirement fund. Please. Does the SCD change after the military deposit is paid in full? Well, it depends on what SCD you're talking about, because remember, there are like 5 or more SCDs. We've got the TSP SCD, the leave SCD, the retirement SCD. It definitely will change, because that's something you need to look at. When we are dealing with, and that's the one that we're concerned about, because we're talking about retirement here. I know for leave, that's a whole different thing, and there is a whole different set of rules for military service and leave SCD. But for retirement SCD, when we're looking at the retirement SCD, we're looking at the amount of service that is creditable towards a retirement benefit. So yeah, and in those cases, the military service would make a difference to the retirement SCD if they pay it in full and that service becomes creditable. So somebody here has actually retired somebody with pre-57 military service in the last 5 years. Congratulations, you've got essentially a kind of unicorn. We don't see those very often. And that's an easy one because they don't need to pay a deposit, the service is creditable, and life is good for everybody. Let's see. Is military academy service creditable for military deposit? Yes, military academy service is creditable. So just be aware of that. Current place 4 years of line service. Okay, I've seen this question before. Merchant Marine service is not creditable. I haven't gotten that question in a while, but just so you know, yes, it is not. Sorry, I'm just going through your questions here. Okay, this sounds like a USERRA question. We've had lots of issues with deposits where the employee took paid and unpaid leave intermittently. Can you walk through the best practice for how these periods should be handled, specifically when leave records are unclear? Well, the leave records need to be very clear. We're going to get into that a little bit in one of the subsequent sections, so just be aware of that. We're going to be talking about that. Okay, I'm seeing lots of case-specific questions, which unfortunately I can't go into right now. Okay. I'm not sure when the CSRS and FERS handbook is going to be updated. We are working on that right now, particularly the military chapter. What an employee do? Okay, here we go. Here's a common one that we run into. We sometimes get photocopies where the member 1 DD214 was placed over member 4 before copying. Are we correct to ask the employee to provide a clean copy of member 4 only DD214? Absolutely. The member 4 copy is the one that has the characterization. Member 1 copy does not. If you get a member 1 copy, that is not acceptable because it doesn't have the characterization of service. And in a lot of cases, that'll resolve your problem, because I have seen probably more, I've seen service that's uncharacterized, that's just uncharacterized due to its length or whatever. But more often than not, what I've seen happen is when it's not showing a characterization of the service, and it's an extended period of time, it's usually because they provided the member 1 copy as opposed to the member 4 copy. So we do need that member 4 copy. Does the employee need to provide HR with the OPM document showing they bought back their time, or does OPM have it on file to give credit when they retire? I'm assuming you're talking about somebody who came from another agency, because otherwise you guys would have it. If that's the case, then, and they paid it in full, ideally OPM should have that record. It should have been sent on a payroll card from the payroll office or the shared service center to OPM. So we would be able to have that. Okay, if you find an error on a deposit that was paid and certified by a prior agency, such as earnings and DD-214s don't match, or the service wasn't Title 10 for prior National Guard service, what is the current agency's responsibility for correcting the deposit? Ideally, you're going to want to reach out to us because we're going to have a payroll card with some erroneous information. And that's going to need to be fixed, and in a lot of cases it's going to be working with the prior agency because you can't correct the payroll cards for the prior agency. So we're going to have to work with that, but you're definitely going to need to notify us. If it's a current employee and you're an agency HR person, reach out to your OPM liaison. We should be able to work with you and work with the retirement section to get that straightened out. Okay, again, somebody's asking about a paid in full receipt. That is fine, secondary documentation, but at the end of the day, what we are going to need is that payroll card, the IRR. Somebody's asking about the IRR too. Where do they get it? That's something that is done through your shared service center or your payroll provider, and it's sent directly to OPM. It's the payroll card that shows the amount of the retirement deductions that are sent to the retirement fund, and they also transfer that money via the IPAC system to OPM to the retirement fund. So that's why we need that. Let's see. Sorry, I'm just going through these. Okay, let's continue on because again, a lot of the questions that I'm seeing are going to be questions that we're covering in this part of the presentation as well. So let's go to this. In fact, this goes right to one of the questions that we had. Again, I'm not going to go into there's a lot of detail in USERRA. We could spend all day on USERRA alone. Uniform Services Employment and Reemployment Rights Act, USERRA of 1994, guarantees certain rights and benefits to reservist and National Guard members when they're called to or volunteer for active military duty. Again, CSRS and FERS Title V definition of military service changed. Military service for USERRA purposes now includes certain National Guard active duty, but only when the employee is absent from federal employment to perform the National Guard active duty and returns to federal civilian employment. So they have to return. Changes related to the service credit deposits required for certain military, which interrupts this service, and that's what we're going to get to. BAL 03105 issued in June 25th, 2003 goes into a lot of detail on this, so you might want to reference that. Now, for concurrent service, the deposit only is required for periods not covered by civilian pay and retirement deductions. You're going to document the civilian salary paid during the active duty from which the retirement deductions were withheld. You're going to document the basic military pay with actual military pay records and civilian pay statements, or document the basic military pay estimated military earnings and pay statements, calculate the active duty period subject to military deposit when there was intermittent use of military and annual leave, which is one of the questions that we got to. There's an alternate method for calculating the deposit, and under USERRA, the amount of the deposit before interest is limited to the amount of civilian retirement deductions which would have been withheld. Now remember, we got this question that linked to this earlier, excuse me, about when FERS RAE and FERS FRAE came into effect. Because remember, RAE and FRAE have higher deduction amounts. When we were dealing with straight FERS, and it was 0.8% of pay that were actual retirement deductions. In most cases, the civilian deductions would be more advantageous. When FERS RAE and FERS FRAE came into play, then in some cases the military deposit, the 3%, may be more advantageous. So you're going to have to calculate that and see. So what you do is you calculate the amount of retirement deductions that would have been withheld from the employee's civilian basic pay during the entire period the employee was in leave without pay. So essentially you calculate the retirement deductions for the amount of time that they were in leave without pay, subtract the retirement deductions that were actually withheld from civilian pay because the employee took leave or something, and then you're going to compare that to the military deposit. So FERS Act, here's an example. FERS active duty from 11/1/2001 to 7/1/2003. They were on leave without pay from 11/1/2001 to 7/13/2003. They returned to duty on 7/14/2003. Now, in the process of this, they had 96 hours of annual leave in December of 2001, 120 hours of military leave in April of 2002, and 60 hours of military leave in November of 2002. So what we do is we look at the actual deductions that were withheld. That was the $73.45. The total deductions, which would have been withheld from 11/1/2001 to 7/13/2003, which was $963.17. And again, remember, the actual deductions that were withheld would have been the 96 hours of annual leave, right? So now we've got the total deductions that would have been withheld, which are $963.17. The military deposit before interest for the period from 11/1/2001 to 7/1/2003 can't exceed $889.72, which is the total amount minus the amount that you actually did withhold. Okay, so that's your base amount. The military deposit cannot exceed that before interest. So now you would have to compare that to what the military deposit is. And based on just the regular military deposit calculation, which under FERS would be 3%, and see what happens there. Now, here's an area where I get a lot of questions, and that's refunding military deposits. Any money paid as a deposit is refunded to a separated employee who applies for a refund of all retirement deductions. Military deposit is part of the total contributions used to determine the amount of a lump sum payment. Okay, so we're dealing with two things here. So say you're an employee, you've been working for a little while, you've got maybe 8 years of civilian service. You also have 3 years of military service, and you paid a military deposit for that time. You leave federal service and you request a refund of your retirement contributions. Well, what's going to happen is we're going to pay out all the retirement contributions for the civilian service, as well as all the retirement contribution, as well as your military deposit that you paid, because that's considered retirement contributions as well now. And let's say you come back to work later on and you want to pay that back. Well, you're not going to do a separate military deposit. You are going to do a civilian deposit for that entire period of refunded service, which is going to include the military service. So that military deposit is, if you get reemployed and decide to make a redeposit for that refunded service, it's going to now include the military service. So that refunded period is going to be treated lumped in with the civilian service. It's not going to be a separate military deposit. It's going to be treated just like a civilian refund, and you're going to pay that back that way. Now, if, let's say, for example, you have same situation, 8 years of civilian service, 3 years of military service, and then you die. There is no spouse that's going to get a survivor benefit or anything. You don't have a spouse, you're single. There's only a lump sum death benefit that's going to be payable. Well, in that case, the military deposit is going to be part of the contributions that would be payable out as part of that lump sum if you had paid that in full. Now, upon application for retirement, generally a completed deposit can't be returned to an employee entitled to an annuity benefit unless the employee elects the alternative form of annuity, which they can only do if they're terminally ill. And there are some special rules around the alternative form of annuity, or the employee chooses not to waive their military retired pay. You can't, once somebody has completed a military deposit and that military deposit is acceptable, it was done correctly, it is military service that's creditable, the person could have paid a military deposit for it, they did pay a military deposit for it, and that deposit is paid in full, the agency can't refund that to the employee, OPM cannot refund that to the employee unless, again, there are two situations, the employee elected an alternative form of annuity, which again, they would have to have a serious medical condition and be terminal. The employee chooses not to waive their military retired pay. In both cases, they're going to need to reach out to OPM. Service covered by the military deposit is not creditable for retirement purposes is another time when you could refund the military service. So let's say, for example, you've got an employee, and this is a completely different scenario, right? So you've got an employee who paid a military deposit, and you accidentally accepted this military deposit, and that service was for Title 32 time. It was not creditable. And that person paid a deposit for it. In that case, you can refund the deposit because it never should have happened in the first place. Let's say the deposit is incomplete. The person started making a military deposit with your agency and then stopped, and then they retired. And now we only have a partial military deposit. Well, remember, in order for military service to be creditable, a person has to make a deposit for the entire period of military service in full before they separate. If this person only partially paid it and then separated, OPM is going to refund the part of the deposit that they made because it's not paid in full. Now, before retirement, a completed or partial deposit may not be returned to an employee unless an election to make the deposit was invalid. So, here is, because we've dealt with this, I think this is a good point to start asking questions. So, let's see. If an employee, okay, we've got something regarding a military. Again, some scenarios here. What do you do if an employee paid a deposit and provided a canceled check, but doesn't have a paid in full letter and no IRR record? Well, if we don't have an IRR, if we can't show that the money was sent to OPM, then OPM never received the money. The person has a canceled check. Whoever the shared service center or payroll provider was that cashed that check clearly took that money, so they need to send it to OPM. So at this point, it becomes a discussion. Again, this is one of those scenarios where, okay, you're providing a canceled check showing that that whoever it was, the payroll provider negotiated that check, they received the funds, that payroll provider needs to send it to OPM. I mean, that's really where we are. And if you're an HR processor, where do I retrieve the IRR or payroll card? I mean, generally, if it's a deposit that was paid at another agency, you may see that in our data viewer if you have access to that. Those payroll cards, if they're imaged, are in our data viewer. If it's not, if it's being paid, if it was paid at your current payroll provider, they may be able to provide a copy to you. At what point is the IRR sent to OPM? In most cases, it's sent whenever the person separates or whenever they change payroll providers. For example, I know sometimes an agency will switch payroll providers and then those records are closed out and they're sent to OPM. Okay, this is a question about USERRA. If somebody goes on to active duty and doesn't return, how do they buy it back? They don't. It's not creditable. That service is contingent upon them returning to civilian service. Exactly. What information is OPM interested in that serves as justification that the employee is not waiving military retired pay? Well, on the application, it asks the employee, are you receiving or have you received military retired pay? It does ask them if it's under one of the provisions where they don't need to waive it. If it's not under one of those provisions, that it asks, are you waiving your military retired pay in order to get credit for it? They would just check no. So that would be what we would need. And of course, if they're not waiving it, in most cases, they don't make a deposit for it. Occasionally, I've seen people make a deposit for military service when they're not waiving it, and then they later on decide to waive it. That's very rare, though. That I doubt you would see that very often. What if an employee leaves before finishing a deposit? Well, it depends on how they leave. Are they leaving to go to another agency, or are they retiring, or are they leaving government and separating from your agency and not going back to a civilian position? If they're either retiring or they're just resigning and they're not going anyplace else, then that's a partially paid military deposit. It's going to depend on what happens in the future. Does that employee subsequently, whether it's days, months, years later, accept another federal position? If they do, then they can resume and finish paying that military deposit. If they don't, of course, interest is going to be accruing this whole time. If they do not return to federal service, or if they retire and it's only partially paid, then we're going to refund the partially paid amount. Okay, let's see. Where can we find the law, regulation, et cetera, that identifies what type of military service is creditable, eligible for service deposit? That would be in the, I don't have the specific reference off the top of my head. It is in our, it is in the law and the regs. It's actually detailed still in chapters 22 and 23 in the SERS and FERS handbook has those references. I'm sorry, I just don't remember them off the top of my head. Can an employee who took a refund choose not to make a redeposit of contributions, which includes military service, upon returning to federal service and just make another military deposit? Included with the current period of federal service, or are they required to pay that redeposit to receive? They have to pay the redeposit. They can't just treat it like another military deposit. They already did that. It's refunded service now. It's treated as civilian, as that chunk of refunded service. Okay. Here's an interesting one. You stated earlier that only OPM can make a determination if an administrative error was made by the agency. Can you please clarify how recent BAL 21-101 payment of interest on post-56 military deposit or Peace Corps or VISTA service deposit with an administrative error changes the administrative error determination? It doesn't change the military, it doesn't change the administrative error determination. Okay, an administrative error is an administrative error. Once it's determined that an administrative error has occurred, that something happened at the agency that prevented an employee from making a deposit when they could have, or refunded or denied them the ability to make a deposit that they were entitled to, or computed the wrong amount. Say they were a CSRS person and they computed it at FERS amount, something like that. That's what we're talking about as far as administrative error goes, or they were told that they couldn't make a deposit for it when they really could. Something like that. Then, so nothing in BAL 21-101 or that change in the law really affects the determination of an administrative error, what an administrative error is. What it says is that as a result of that, so now we've determined that there's an administrative error. Something happened at the agency, there was a mistake at the agency that prevented this employee from being able to do this when they wanted to. Which means that at that point, this new BAL says that the agency may pay the interest that has accrued on that as a result of that administrative error. So the administrative error is going to be the administrative error regardless. Nothing changes the determination as to whether or not that happened, whatever that situation, whether that situation was an administrative error or not. That's just a decision that is separate. Now, once we make that decision, then normally what would happen is we would say, oh, there's been an administrative error. Agency, you need to accept a military deposit from this person, compute it with interest up to this point. And it used to be that the employee would have to pay everything, and there's no provision in law that allows for a waiver of interest. So that's why this BAL 21-101 came into play, because now it says that the agency can actually pay the interest for that person. Again, we can't waive interest, but the agency can pay the cost of, can pay the interest for that person. They can essentially absorb the cost of that administrative error, because the employee would have owed the deposit amount anyway, but the interest that would have accrued on it as a result of the administrative error, the agency can pay that because it was the agency's fault, because it was the administrative error done by the agency. So that's what that is saying. I hope that clarifies that one. Okay, here we go. This is one that's come up quite a bit. We have some cases where an employee paid military deposit with prior agencies, but after reviewing and verifying, National Guard employees were not eligible to buy the time back. We have seen this. It's like Title 32 time. Definitely reach out to us. I would say reach out to your liaison. We can get that to the processing sections. We really need to get that. We can get that money back to the person. If they shouldn't have paid a military deposit, we want to catch that before the person actually retires. We want to make sure it's a clean record, and so we would need to work with you, get the documentation, and then be able to refund those deposits back to the employee. If I paid a military deposit and now want to retire, request a refund, I'm not eligible for a refund. Okay, this is a whole other question here that isn't necessarily specifically military related, but if you're eligible for an immediate retirement, you cannot request a refund because you know, you would just be getting retirement contributions back. You wouldn't be getting and then you wouldn't be eligible for an annuity. You wouldn't be eligible to retire. But once you were eligible for an annuity, that precludes you from getting a refund. Now, The only way you can do that for military service is if you are eligible for military retired pay and you choose not to waive the military retired pay, and you write into us and specifically say, I want a refund of my military deposit because I choose not to waive my military retired pay. Okay, so somebody is asking if somebody gets MRP under service-connected disability or instrumentality of war, is that found in the DD 214? A lot of times not. There's usually separate documentation that comes along with that, and it's usually the retired pay award, or there's a letter that's involved with that states that this is a disability incurred in combat, or combat-related disability. This is what we're looking for. It's usually not on the DD 214. DD 214 could show any number of things. It could show disability. It could show anything like that, but usually they don't show that it's combat incurred. Is it advantageous for someone to make a military deposit when they're going out on OWCP? Well, it depends. I mean, we need to look at this. This is one of those situations where you're really looking at this as it depends. Are they, if they're going out on workers' comp, are they also applying for disability retirement, which we encourage, right? And if that person expects to live to be age 62 or older, when we actually do the third computation, you know, the first computation for disability retirement benefits is 60% of the high 3 average salary, and then it's 40%, and then we do the final computation where we add all the time on the disability rolls along with all the time that they actually performed. It may be advantageous to them to make the deposit, because again, remember, if they separate, they're not going to be able to make the deposit. So you really need to be on board with counseling them before this happens. And a lot of times people are not on OWCP until they retire. So they're at some point they may come back onto OPM's rolls if they've retired on a disability, or they may be recovered and go back to work with another federal agency, at which point interest is going to be accruing that whole time on any future military deposits. So it's always in their best interest, in most cases, to make the military deposit. The only thing I could say is that there may be a couple instances where it may not be, and that would be like, for example, if they were terminal, but even then, if they had a spouse and this took them to the 10 years, I mean, it's really something that you're gonna have to look at on a case-by-case basis, and weigh all the options. But I would just be very careful about looking at that. In general, it's best for people to make a military deposit as soon as possible, because you essentially stop accruing interest. Is it ever advantageous for a military retiree to waive their military retired pay in exchange for a FERS retirement? Well, they're never waiving it in exchange for it. I mean, I guess, you know, they're adding it to their service. So you would really need to look at how much they're getting paid by the military, what their military retired pay is, and then do two estimates. Do one without the military service for FERS and one with the military service for FERS, and look at how much it increases the FERS benefit. In a lot of cases, it used to not be worth it, just because with the military, generally speaking, you don't normally stay a low-graded employee in the military. You generally have to move up or out. And so by the time you reach retirement age, you've generally moved up the ranks, and military retired pay is calculated more generously than our benefits. So you would really need to look at that. What it comes down to is, I can't answer that specifically. You need to actually do an analysis of it, do the comparison, do the annuity estimate with and without the military service, and then look at how much they're receiving in military retired pay and counsel the person that way. If you don't feel comfortable doing that and looking at the dollar amounts and working it out, they might want to see a financial planner and take those estimates to them. But you're just providing them the information. I need to get back to some more slides because we do have more to get through. We still have to talk about interest accrual dates. So let's go to, I wish I could spend all day answering your questions. Unfortunately, we've got more stuff to cover here. So computing the deposit and the interest, you're going to compute the amount of creditable military service, determine the amount of basic pay, compute the deposit, and compute the interest. Now, as I said, the amount of deposit for CSRS people is 7%. The amount of the military deposit for FERS people is 3% plus interest. Both CSRS and FERS provide a 2-year grace period on deposits. After the 2-year grace period, interest is accrued and compounded annually at a variable interest rate. For employees who were first hired under CSRS before 10/1/83, interest begins accruing on 10/1/85. You're going to notice all these 10/1 dates. The reason for that is our fiscal years begin on October 1st. So all these changes happen with fiscal years. So just be aware of that. That's why you're going to see all these 10/1 dates here. For employees first hired under CSRS on or after 10/1/83, interest begins 2 years from the date the employee was first hired under CSRS. If the military service was performed after the date of first employment and after 10/1/83, interest for that period of military service begins 2 years from the date that the employee returns to a position subject to CSRS or CSRS offset. For FERS employees, if you were first hired before 1/1/87, interest begins to accrue on 1/1/89. For employees first employed on or after 1/1/87, interest begins to accrue 2 years from the date the employee was first employed subject to FERS. If military service was performed after the date of first employment and after 1/1/87, interest begins to accrue 2 years from the date the employee returns to a position subject to FERS. So employees who transfer to FERS and have a CSRS component continue to be under CSRS military deposit rules for military service performed before the transfer. For employees who elect FERS coverage and don't have a CSRS component, interest begins to accrue 2 years from the date of transfer. Now, here's this IAD, or interest accrual date, that we were talking about. This interest accrual date is the date each year when accrued interest is added to the amount of the deposit owed by the employee. The employee's first interest accrual date is the date 1 year after the date of the interest-free grace period ends. The IAD falls each year on the anniversary of the first IAD until the deposit is paid. So the initial IAD for employees who perform military service after the date they are first hired in a position covered by CSRS and after 10/1/83 is 3 years from the date the employee returns to a position subject to CSRS deductions. Okay, so this is, we've been talking about before all those 2-year periods. So you've got a 2-year interest-free grace period, okay? Then interest starts accruing after that 2 years ends. For that first year that interest starts accruing, if you pay it off before your IAD, before the 3 years, then there is no interest. But once you hit that 3rd year, that's the IAD, that's the interest accrual date, that's the date that gets added. So every year you accrue interest for a year, and then on that anniversary, it gets added to the deposit amount. If you pay it off before you hit that anniversary, you don't accrue interest for that year. So let's look at an example of this. We've got somebody who was first employed on 7/3 of 1973. They have military service from 10/2/75 to 10/1/77. The grace period expires on 9/30/85, which means that 9/30, 10/1, okay, that the deposit becomes subject to interest on 10/1/85, right? So we've got 2 years. And then, because remember, for CSRS people, it started on 10/1/83. So we've got 2-year period of interest free. Then on 10/1/85, which is 2 years later, it starts accruing, and your first interest accrual date is 10/1/86. If you paid that off on as late as 9/30/86, you wouldn't have any interest. But once you cross the line and hit once 10/1/86 happens, now you've accrued a year of interest. And then interest starts accruing again from 10/1/86 to 10/1/87. So you've already accrued interest from 10/1/85 to 10/1/86. So let's say you missed that 10/1/86 date. Okay, so 10/1/86 interest gets added for 1985. 1986 happens and you're like, I really want to get this paid off before I accrue any more interest. Well, interest is starting to accrue as of 10/1/86 and it keeps accruing, but as long as you pay it off before 10/1/87, you won't get hit with the interest from 1986. You'll still have the interest from 1985, but you won't have the interest from 1986. Because remember, the other thing is that interest from 1986 is going to be on the increased amount. So you're going to have the base amount of your military deposit plus the interest that was added, and the interest for 1986 is going to be the military deposit plus the interest that accrued from 1985 to 1986. So you're going to be paying interest on top of interest. It's going to be compounding. So let's look at another example. We've got somebody first employed under CSRS on 3/5/75. They separated on 7/22/86. Military service happened from 88 to 91. They were rehired under CSRS on 6/3/92. The grace period expired on 6/2/94, right? So this is like 2 years of interest-free grace. So the initial IAD is going to interest starts accruing on 6/3/94 because you got that 2-year period that's done. So their initial IAD, their initial interest accrual date is going to be 6/3/95. That's when the interest that accrued from 6/3/94 to 6/2/95 gets added. On 6/3/95, if it isn't paid off by then, we add a year of accrued interest. Then it starts accruing again if they don't pay it off. Here's another example. We've got somebody who had military service from 76 to 80. They have civilian service from 84 to 12/31/86. They are a FERS employee because if you look at this, and for those of you who are familiar with the coverage rules, if you've done coverage before, you look at this and they're subject to Social Security already because they're in 84. The first question we're going to ask, they're automatically placed in FERS on 1/1/87 because they don't have 5 years as of 12/31/86. So they're an automatic FERS person on 1/1/87. Their interest accrual date is going to be 1/1/90. Okay, so if you think about this, 1/1/87 to 88 is 1 year, 88 to 89 is 2 years. That's their interest-free grace period, because that's when FERS started. And then from 89 to 12/31/89, it accrues interest. And on 1/1/90, boom, interest is added. So that's their interest accrual date. Got another one here, military service from 86 to 88. Civilian service, 8/22/89 to present. The person is a FERS person, obviously, because their first civilian appointment is 8/22/89. So their interest accrual date is going to be 8/22/92. So we look at this again, 8/22/89 to 8/22/90 is 1 year. 90 to 91 is the second year. So 8/22/91 all the way up to 8/21/92 is when it's accruing interest. So if they pay it off any time during that period in 91, then they won't accrue interest. But if they miss it and 8/22 happens, they've had a year of interest added. And then 8/22, every year thereafter, it's going to accrue interest until this thing is paid off. Interest rates are computed on a calendar year basis, January 1st through January 31st, or through December 31st. Boy, that would be a short year if it was January 1st to January 31st. If the IAD isn't January 1st, the interest rate is going to reflect a portion of the rate for the prior year and a portion of the interest rate for the current year. So we're going to have a compound interest rate here. So the way we do that is we have to prorate the interest rate so we can come up with a composite interest rate. So OPM math, we assume there are 30 days in each month. We've got 3 months here, October through December, which gives us a quarter of a year, 0.25. There are 360 days in a year, again, OPM math here, right? So the fraction of interest in a calendar year posting occurs. So we've got a full year minus 0.25 or 25% equals 75% or 0.75. So we have to look at the interest rates here. In 1985, the interest rate, and you guys are going to be shocked by this, but these are real interest rates. In the 80s, interest rates were really high. 1985, the interest rate was 13%. So we take a quarter of that because remember, we only had October, November, and December. So we only had 3 months, which was a quarter of a year, 0.25 or 25%. So we take 13% interest rate and we prorate that for those 3 months, which gives us 3.25%. Then in 1986, the interest rate actually dropped to 11.125%. So we have to take 3/4 of that, or 75% or 0.75, which gives us, again, a portion of an interest rate that they accrued for that year of 8.344%. We add those together and we come up with a composite interest rate of 11.594% for that year, for that period of time, for that 1 year. Okay, so now that we have talked about interest accrual dates and compounding interest, I'm sure we're going to have some questions on that. So let's see. So just so I'm clear, employees do not have an opportunity to request a refund on their paid in full military deposit. That is correct unless they are eligible for a full refund or unless they are in receipt of military retired pay that they would need to waive and choose not to waive it. Okay, this is a good, this one we get a lot. I'm really glad somebody asked this because I was going to bring it up if I didn't see the question in here. If someone first entered federal service, for example, 1 year, left for 2 years, came back to federal service again and wanted to do a military service deposit, is the IAD date based on the first year or based on the second time they came back? Well, interest accrual date is the interest accrual date. So anytime somebody comes back from military service and enters a civilian position, they have 2 years of an interest-free grace period, and then interest starts to accrue. So let's say, for example, it's me and I had some military service and I came in January of 91, okay, which I actually did. I came to OPM in 91. And so my military service, that was a covered position. My military service, I would have a 2-year grace period. So I would have a period of time up to January of 93 where interest would be free. I would not accrue any interest. Starting in January of 93, I would have 1 year where I would start accruing interest. And on my anniversary of the date that I first became covered, that is going to hit And that is going to be my interest accrual date. That January date is going to be my interest accrual date until that is paid off. So let's say I leave federal service, even though I've got a break, say I left in, I didn't pay it the first time, right? So 91, I got 2 years. I go 92, 93, then I have that interest-free period. That was my interest-free period. Interest starts accruing in 93, 94. I get hit with interest for the first year. And then I resign sometime in 94, and I have a break in service of like 6 months. And then I go back to work for another federal agency. My IAD is still that first IAD. I've accrued in, even though I wasn't even in federal service for a period of time, interest is still accruing. Interest will continue to accrue once I leave military service and entered a covered position. That became my interest accrual date. Let's see. What is the advantage of paying military deposit or combining service with federal? Well, the advantages of paying a military deposit are that, you know, you add service to the computation, which gives you more money. It also allows you to retire earlier if you are already, or if you're close, or if you're going to be eligible. It allows you to retire earlier because you have more service. So it's really dependent upon that. That's really the biggest benefit. And of course, if you're not getting military retired pay, you've had that military service, you know, you can get it credited towards an annuity. So earning under FERS, earning an extra 1 or 1.1% of your high 3 average salary for those years that you were in the military is not a bad deal. Does interest accrue also for the time of the break in service? Yes, it does. I'm glad you asked that. Like I said, we kind of tried to clarify that. Yeah, again, we're getting the same question. The interest accrual date is your first interest accrual date. The first time you enter a covered position after military service, that is your interest. That 3 years from that date is going to be your interest accrual date. Okay, and again, that's what I'm seeing right now. I know we are really close to ending here. We've gone actually a little bit longer, but that's okay. I don't mind staying on here for you guys. I'm glad to be here. I know I didn't get to all your questions. I can tell you, I believe if you haven't gotten a copy of the slides, we can get them to you. That's not a problem at all. If you have any questions, you can email us at benefits@opm.gov. I wouldn't email these individual questions. But you know, if you need copies of those slides or anything like that, hopefully this has been helpful to you, and it's been great, great presenting for you. I hope everyone learned something, and thanks a lot.